Good evening everybody. Welcome to this match for the 8th of finals between two teams who qualified from the group phase. This is the Inter-University Law Debate Tournament 2023. So I will give the floor to my colleague to introduce the match, the teams.
Thank you very much. My name is Anna Maria Urbanova, and together with my colleague Aurelien Bolotach, we are representing Corex Foundation, the organizer of the Hague Inter-University Law Debate Tournament edition 2023. We are very delighted to welcome the teams of University of Manchester from the United Kingdom and Catholic University of Lille from France. Well done on reaching the final phase of the competition, and well done on your group phase matches. The teams have received the same debate statement at the same time to prepare for today's session. That was 7 days ago. The debate statement released to the teams for the 8th finals is that donors of biological material used in commercial research shouldn't be allowed a certain level of rights in regard to donated material, for instance, by patent co-ownership in events of patented discoveries. So the two teams have prepared for both sides of the argument. In a short while, the positions allocated for debate match will be decided. But that would be all from my side as an organizer. It's now time for the students to introduce themselves, and we're also very delighted to welcome 2 of the 3 judges present for the live session. Starting with the students of the University of Manchester, Ms. Andrea Deina Panait, the floor is yours.
Hello, my name is Diana. I'm delighted to be here to debate you guys. I'm a second-year law with politics student at the University of Manchester, and yeah, I'm excited to get the debate going. Thank you.
Thank you very much. Welcome. Mr. Arnold Bish from Catholic University of Lille, the floor is yours.
Hello, my name is Arnaud Beg from the University of Lille. It's a pleasure to be here. I'm a first-year student in European law, and I'm glad to be here for this debate.
You're welcome. From University of Manchester, welcoming Mr. Beach.
Good evening, everyone. I'm Adam Beach. It's an honor to be here. It's very exciting being in the knockout phases. Yeah, good luck to our colleagues, and thank you for the judges for being here as well.
You're welcome. From Catholic University, Ms. Dwyer.
Hello, my name is Blanche Dwyer. I'm from the Catholic University of Lille, and I'm, like Arnaud, a first-year student in European law. Thank you very much for having us and for preparing this debate for us. It's an honor to be here.
Thank you. Welcome from University of Manchester, Ms. Al Abida.
Hello, my name is Emel. I'm a second-year law student at the University of Manchester. And I'm very excited to see what today's debate brings to the table.
Thank you. Thank you for joining us and welcome. And also very delighted to welcome 2 of the judges already seasoned in this edition. Welcome to Professor Casaines.
Hello again. It's very nice to meet these young students, and I just want to wish them the best of luck for their participation in a few moments, and thank you for having me.
Thank you for joining us and welcome. Professor Issa Adedokun.
Yes, I equally want to say that I'm happy to be one of the judges of this competition, and I want to wish the teams that have made it to this round best of luck, and I want to sit back and equally learn from the students. All the best.
Thank you very much for joining us. Welcome. My colleague will now shortly share his screen with the allocation of position, so we'll now know in a bit which team is starting the match.
Yes, so I will share my screen. In a few seconds, you will see the flags, the name of the universities, and as well the different positions. So normally in a few seconds, so now you should see the screen. So yes, 2 positions possible in favor or against for the University of Manchester or the Catholic University of Lille. So we click in the center, up, and voila, and we'll know which position. So this is University of Manchester who defends the position in favor, and then will start as well the match. As a consequence, that will be the Catholic University of Lille who defends the position against the motion. So concretely, the University of Manchester will defend the position that donors of biological material used in commercial research should be allowed a certain level of rights in regards to donated material, for instance by patent co-ownership in events of patented discoveries, while the University of Manchester will defend the position that donors of biological material used in commercial research should not be allowed a certain level of rights in regard to donated material, for instance by patent co-ownership in events of patented discoveries. So now my colleague will share the screen for the 5 minutes.
Yes, just to confirm, the position in favor is with University of
Oh,
Manchester.
sorry, yeah.
So University of Manchester will be starting the match. So again, just to confirm, the donors of biological material used in commercial research should be allowed a certain level of rights in regards to donated material, is the topic that will be defended by the University of Manchester debate team. The debate team of Catholic University of Lille will be defending against this position and will be the second team to start. And that said, you will now have 5 minutes to finalize your preparation. The screen share will begin shortly. And best of luck to the two teams, and looking forward to your debate. All right, thank you very much. Your time for preparation has now passed. We'll be starting the debate session with the team in favor of the debate statement. So for this match of the 8 finals, the University of Manchester, you will be starting for your opening statement. You have 4 minutes whenever you're ready.
Am I audible?
Yes, you are.
Okay. Good evening, esteemed colleagues and judges. I would like to welcome you from our side of today's debate. Our case will outline why donors of biological materials should be granted rights in the context of commercial research, where the very intention of researchers is to monetize their findings. In my substantive, I will establish that owners retain their ownership of biological material, although they do donate it for commercial research. Diana will then establish that as donors retain ownership, we should construct a legal framework which recognizes the rights that adjoin preparatory interests. And Adam will then solidify our case in discussing the benefits such recognition would yield for the greater sake of society, such as an increase of donations and widespread scientific advancement. I would now like to move on to my substantive. Jurisprudential discourse has long questioned the ambits of property rights over one's own body. John Locke contended that every man has a property in their own person. The Court of Appeal decision in R.V. Kelly confirms this, as it held that where a part of a body had undergone a process or application of human skill designed to preserve it for medical or scientific research, it acquired a value and became property for the purposes of the Theft Act. The question here is still whom ownership of the property is vested in. The case Yearworth established that donors have proprietary interest in material as they succeeded in bringing a claim of personal injury where donated semen samples were inadequately stored. This clearly shows that donors must have some degree of rights of ownership over the biological material that they have donated in order to bring a claim. When biological material is donated, researchers are not granted exclusive physical control over the material and therefore cannot be considered to have full ownership. The Code of Medical Ethics enables donors to withdraw their consent to use the material at any point throughout the research, and scientists are not allowed to make use of material for the purposes of other respective research projects. For example, a researcher would not be permitted to sell a donor's blood to another company where the aim of the research is to find a cure for hemophilia, or use a kidney for a paid organ transplant where the aim of research was to assess kidney malfunction, because the donation was on the condition of a specifically delegated use. Like these examples, when donating biological material, the transfer is often for a specific purpose and is conditional. If the transfer is conditional, it clearly indicates that a complete transfer of proprietary interests has not occurred. At the most, it may be equated as a conditional gift or a bailment. This implies scientists do not have a right to possess, namely, the right to have exclusive physical control over subject matter. Instead, it is clear that donors retain those rights as they are still in conditional ownership of the material. Existing legal frameworks already recognize ownership of biological material and the ability of donors to delegate use. The Human Tissue Act 1961 holds that consent must be obtained for the removal, storage, and the use of donated human tissue, as the source of material should have the agency over its management. Researchers implicitly recognize ownership, though, in that the contracts donors sign establish that researchers do not have exclusive control over the material, but they fail to go the extra mile in expressing that this implies they retain ownership and could therefore monetize the benefits of its use. If we were to give researchers exclusive ownership over biological material, they could easily sell these materials to other people whose intention in treating the bodily material is unknown. If there is no legal regime to recognize the proprietary ownership of donors, altruistic persons who would have ordinarily donated their body material might be disinclined to do so, and also might feel exploited as they're the only people involved in the research project who are not entitled to monetization. This may become a foreseeable future where the legal arena fails to articulate whom ownership is vested in through a standardized framework, although it does implicitly recognize that it is vested in donors by not granting it to researchers. This is not sufficient, and there is therefore an urgent need to move to a legal reality where we clarify that proprietary interest belongs to donors. Thank you.
Thank you very much. Now for your opening statement in the position against the debate team of the Catholic University of Lille, the floor is yours.
Well, we think that the donor of biological material used in commercial research should not be allowed a certain level of right, such as patent co-ownership, for several reasons. But first, it is important to note that biological material are materials that are used and produced by living organisms such as blood, bone, protein, muscle, and other organic material. And it is known that research using human tissues has resulted in numerous commercially available products for use in both research and treatment. The development of this product raised questions about who holds property right in human biological material, how to distribute profit derived from human tissues equitably, and what constitutes appropriately informed consent when patients donate biological material to research that may ultimately result in one or more commercial products. But to put it in short, commercial research based on donation of biological material is a complicated subject, requiring a lot of investment, effort, and time. But when dealing with such essential subject, time is a luxury that we cannot afford. Each process that we have to go through in order to obtain the finished discovery takes up a lot of resources. So imagine if on top of that, we have to manage and track the right of numerous donors. Indeed, the right of donors such as patent co-ownership could become a complex and time-consuming process. When we think about it, this added administrative burden would slow down the research process and divert resources away from the primary goal of scientific discovery. Another point that we can raise as to why we should not allow a certain level of right to donors is that doing so will not be an advantage for the industry, but a burden in terms of inhibiting the innovation. Because if we do grant patent co-ownership to donors, the consequences could be that it may create a legal and financial barrier for researchers and companies seeking to develop new products and therapies. This barrier could have for effect to discourage investment in research and greatly impact the advance of researchers and companies and even hinder the overall progress of scientific innovation. And talking about scientific innovation, it is important to point out that donors do have a part to play in the research process, but while they provide valuable biological material, their individual contribution to the overall research process is often small compared to work of people like researchers, scientists, and institutions compared to the work, and the fact of granting them patent co-ownership may not accurately reflect the proportionate value of their contribution. But as I said, it is true that donors have an essential role in the research process. So what if we could give them an alternative compensation method? One that will not take up the time and resources that a patent co-ownership would do, that will allow the whole research system to function as efficiently as possible. Indeed, there are other ways to recognize and compensate donors with granting them patent co-ownership. For example, donor could be acknowledged in research publication, receive update on research progress, or be offered financial incentive for the participation. These alternatives may be more appropriate and less disruptive to the research process.
All right, thank you for your submission. We are now entering the first round of rebuttals. For your first rebuttal of 2 minutes, debate team of University of Manchester, the floor is yours.
Just making sure you can hear me.
Yes, loud and clear.
Okay. Dear colleagues, esteemed judges, and distinguished members of the public, I am privileged to appear before you today to advocate for the granting of donor rights over biological material utilized in commercial research. The proposition firmly believes that donors must be confirmed with co-ownership over their biological material in order to ensure that they receive appropriate protection for the unjust exploitation during the process of commercial research. Firstly, confirming ownership to donors would confer them a sense of autonomy and control over their bodies. This is crucial to acknowledge that the utilization of biological material for research purposes constitutes a personal and sensitive issue that shall not be taken lightly. Donors have the powers to have a say in how their materials are employed. Strengthening this right would afford the legal safeguards to donors and align it with existing laws. The right to privacy is one of the fundamental rights that donors shall enjoy with respect to their personal information and genetic data, as well as the right to withdraw consent for the utilization of their biological material in research at any time. These provisions are consistent with Article 9 of the European General Data Protection Regulation. which recognizes that biological material consists of personal data such as medical or genetic information. Secondly, confirming ownership upon these donors would enable them to partake in the financial benefits that ensue from research. Commercial research often leads to patentable discoveries, and donors should be entitled to have a share in any financial benefits that may arise from the exploitation of their biological material. This would establish a more equitable system that acknowledges the contribution to donors in scientific progress. For example, Convention on Biological Diversity, the EU Directive 98/44 EC on the legal protection of biotechnological inventions, and the Brazilian Biodiversity Law 2015 all include protocols and provisions for the financial compensation of donors. However, these legal frameworks lack international binding standardization. In conclusion, granting ownership and rights implicitly to donors over their biological material is vital, ensuring their autonomy and control over their bodies and creating a more equitable system that recognizes their contributions to the scientific research. Adam will now take our case further and discuss the importance of cultivating trust and transparency between researchers and the general population. Thank you. I ask you to support this motion today.
Thank you very much. For the first rebuttal of the Catholic University of Lille, the floor is yours.
Thank you. Thank you for your arguments. However, our position stands. You speak of how allowing a co-ownership of a patent for donors would protect them and give them a sense of autonomy. However, I strongly disagree. If we allow co-ownership of a patent, it means rights will be given to the donors for their biological material, but this can go very far. Where do we draw the line between giving the donors right and giving the researchers freedom? Indeed, if we take the example of a person donating blood for research, and this research ended up leading to a dead end or leading to maybe something dangerous, the creation of something dangerous, this person could demand to be reimbursed or ask for damages because of the misuse of their biological materials because they have a co-ownership of the patent. This is quite preposterous in my opinion, as a donation is supposed to be a generous contribution, not a weapon to use against researchers in order to gain money to their expense. Moreover, the biological materials of a person are used for research. What if a problem occurred in the research and again something dangerous was created out of this? The donors would no longer want credit and no longer want a co-ownership of the patent. So I think it's quite hypocritical, as the donors asking for credit is only to satisfy their ego. Furthermore, you spoke of the fact that this could financially benefit the donors, but if the donors take financial benefit from their donation, it is no longer a donation as they're receiving money, and the European Commission has been quite clear on the matter. It is unethical to commercialize the human body, and it goes against the human dignity and integrity. And historically speaking, courts have often gone against donors being remunerated for their donations. Thank you very much.
Thank you very much. For the second rebuttal, debate team of University of Manchester, you have 2 minutes.
Hello. Firstly, I would like to address our esteemed opponent's arguments regarding co-ownership and the problems it might lead to. With giving donors certain rights, it actually gives them all rights, meaning that they can withdraw consent at any time. This kind of negates that whole argument you just made about them having ownership to things they disagree with. Their first speaker then also talked that it could be a burden and would slow down the scientific discovery. My following argument will explain why it will not do that. Because donors of biological material used in commercial research should be allowed a certain level of rights in regard to donating material, as it would greatly benefit society. Firstly, by giving donors a certain level of rights, it would greatly increase donations. If we analyze the current and past legal frameworks, we can quite clearly see that we protect donors more intensely. It results in more people donating. The Declaration of Istanbul, which was created in 2008, and the WHO Guiding Principles on Organ Transplantation, which was updated in 2010, resulted in more protection for donors, which in turn encourages donations. This is demonstrated by the European Parliament, as they stated that between 2008 and 2015, the number of organ donors at EU level increased by 21%. This surge in donation rates resulted in 4,600 additional transplant operations. As we can see, when we protect donors, it saves lives and benefits the whole society. If we protect them even further by allowing them a certain level of rights, it would increase donations even more. Secondly, giving donors a certain level of rights would promote ethical commercial research by ensuring that they are not being unfairly exploited by companies. Lastly, donors play a crucial role in the development of new treatments and technologies, and by giving donors a certain level of rights, ensures that their contributions are recognized and valued. Their recognition is vital. Developing the current framework to fully protect this right is essential for the ethical development of research. Donors should be allowed a certain level of rights in regard to donated material, as it would increase donations, save lives, encourage more advanced and ethical research, and recognize their contributions, all of which would greatly benefit society as a whole. Thank you.
Thank you very much. For the second rebuttal, debating of Catholic University of Lille, you have 2 minutes.
Thank you for your arguments. You speak of how giving a co-ownership of the patent would increase donations. However, as I've said previously, if they have a co-ownership of the patent, they would receive money, which would make them no longer donations. They would be remunerated. However, the European Union is strongly against selling people being able to commercialize their body and body parts. Moreover, you said that this would benefit society by people, by an increased donations if people were allowed rights. However, most donations are not actually originally donations for research. Often people are donating biological materials for transplants, but they are often it appears that they are not viable for their original purpose and they are repurposed. Therefore, should someone really deserve praise and recognition for something that was an accidental donation? A patent confers a person rights over a creation and over its commercialization. However, why should a person making a donation have a right over this donation when they didn't even do it consciously or intentionally? Moreover, this could be quite complicated to see where credit should be given and where co-patency should be allowed. If a person is brain dead and their organs are repurposed for research, how do we praise this person who has died? Or if a person is a sperm donor, should they have rights over a child that is born from their donation? This seems to be quite excessive. No one else who makes donation is praised, so why should people who are giving biological materials for research be praised more than people who are doing donations in other domains, especially if it's often quite accidental or unintentional? Thank you.
Thank you. Now entering the conclusions and the final stage of the match, University of Manchester, you have 2 minutes.
Can I start mine?
You're audible.
Oh. No, sorry. We couldn't hear you. I apologize.
No, it's all right. You have 2 minutes for your conclusion whenever you're ready.
Thank you. Apologies. Honorable judges and esteemed colleagues. First of all, points made by team opposition today. First of all, they have mentioned that co-ownership and giving rights to donors would be a bit too complicated and would burden the scientific process of research. However, we believe that we managed to counter-argue these points because, on one hand, as we've mentioned, the patent comes after the discovery was made, and therefore the research process in itself will not be put any burdens on. Secondly, we should not be afraid to make the legal framework more complex, because this way we will manage to protect donors and encourage people to donate more, as Adam has put in his point. Now, the proposition for donors' rights is not only a moral, but a social imperative. The allowance of donors to have a say in their use of biological material can catalyze a shift in the realm of donations, ultimately culminating in the preservation of more lives. The augmentation of protection of donors, though, the attribution of ownership rights will foster a sense of empowerment in donors, translating into a positive correlation in donations. Moreover, the recognition of donors' entitlements leads to a sizable pool of biological material, resulting in more advanced research, innovations, and discoveries. The benefits of these advancement researches in biotech and medicine are vital for the growth of society. Now, the promotion of ethical commercial research is crucial as well. This is a point we've made in our case. With the attribution of donor rights, we can ensure that donors are not going to be exploited unfairly for the quest of the company's monetization. It is of utmost importance that we safeguard these rights of donors and prevent the mistreatment of their contributions in the scientific progress. Now, to conclude, donors should be granted a certain level of entitlement with respect to their donated materials, because this results in increased donation, preservation of lives, ethical research, and recognition of donors' contribution to the scientific scene. Now, in conclusion, the impact of this measure will resonate throughout society, benefiting us all. Thank you.
Thank you. Debate team of the Catholic University of Lille, you have 2 minutes for your conclusion.
In conclusion, not granting. Wait. Can you see me?
No, we cannot see you. Now we can see you.
Okay, thank you. In conclusion, not granting a right to donor of biological material using commercial research such as patent co-ownership can help avoid complexity and administrative burden, prevent the inhibition of innovation, more accurately reflects the value of individual contribution, and allow for alternative compensation method that may be more suitable and less disruptive to the research process.
I believe we lost you there for a second. The timer is paused.
Yeah, sorry, can you hear me?
Yes.
Oh, moreover, we believe that this is immoral to grant rights to the donors as a donation is supposed to be an altruistic act, and this credit would only be mostly be for egotistical reasons. Moreover, it might lead to a lessening of donations, contrary to what the opposition has said, because, well, these donations would receive incomes, and therefore, and receiving income for donation is actually frowned upon. And it may also create, in a way, a sort of dictatorship of the donors. How far can their rights go, and would it be detrimental to the researchers who would not have as much freedom in what they would do with the donation of the material? Moreover, it seems as though it would be complicated to adapt credit in each situation, as there are many different situations of donations, as we have mentioned before. A person who has died and does a donation unwillingly, or a person who originally donated for a transplant and then it's repurposed for research. How do we give them credit when they originally did not even know that they were doing this donation? So in conclusion, we do not believe that rights should be granted to the donors.
Great. Thank you for your submission. This now marks the end of the match. On the side of the rules, just a slight note, this is somehow accepted due to the technical difficulties that your team has faced. However, it is one speaking position per speaker. Speaking positions aren't shared. All right. That said, well done to the two teams on the research and the execution of your research during the debate. It's a definitely challenging and still developing topic. I hope it has been an interesting experience researching and learning more about it and the law behind it as well. So now a little bit of information from my side, giving you a bit more time to take a breather, relax before we jump into the feedback session. So as per usual, starting with the teams, giving a bit more time to judges to decide what they would like to share with the students present, starting with the University of Manchester. Ms. Amal El Abida, how did you find the debate? Did you have already a chance to see this topic in your studies?
Definitely not. Like it's a topic that we've like never covered or thought of, and definitely was very interesting researching it. But more importantly, I think what made this debate even more interesting than any of the debates we've had so far is the fact that the whole team has found itself without an opinion on the actual motion. I feel like before we were kind of siding with one side, but this time it's, I don't know, I'm fenced myself. I don't know what side I agree with. But yeah, very interesting to debate this motion. So thank you to both sides.
Very much for the feedback. Ms. Dwyer from Catholic University of Lille, how did you find the topic? Did you already have a chance to encounter any of the aspects that in your studies, perhaps?
No, we had not seen this at all, so it was very interesting to research, and I completely agree with him. Well, like I personally did not really have an opinion on this matter, and it was really interesting to have to take such a radical opinion, I would say, because I mean, refusing all rights to donors is quite radical. So I think it was very interesting to sort of search for this and also to advocate for something so extreme.
Sometimes really the positions do tend to give the students the possibility to argue something that they really wouldn't argue for themselves during the perhaps day-to-day discussions. Ms. Panate, how did you find the topic? How did you find arguments that you heard during the match, the preparation?
Definitely through the whole competition, I had a lot of fun and learned a lot of things about international law. And not only I learned how to research and learn myself. And this match was definitely no exception because it was unbelievably exciting to debate you guys and also learn more about this very niche topic, because obviously none of us has had any immersion in this topic before, and it was fun to kind of see the medical side of law and how other disciplines, you know, are covered in international law. So it was definitely a great learning experience and a very fun debate. So thank you to the opposite team, and thank you, judges, for your time.
Thank you very much, Ms. Beck. Mr. Beck, apologies. How did you find the preparation for today's match, the arguments and the debate?
Could you repeat, please? I did not really heard.
Yes, of course. My question is, how did you find the preparation for the match? What did you think of the match itself, the arguments that you heard?
Well, the preparation of the match was quite hard because it's a subject that obviously we never really take the time to interest ourselves into. So it was the part that was kind of difficult, if I may say. But it was interesting to know more about this subject that, in fact, that we know about in the start. And I think the most exciting part about this match was, well, to meet the opposing team, which was a real pleasure to debate against you. And I thank all the organizers for able to make this possible and safe. Thank you.
Thank you very much. Mr. Beach, how did you find the present preparation? Did you perhaps hear any arguments that your team has prepared for the opposing side?
Yeah, we definitely heard some of the arguments we presented, but they kind of went down a different avenue than we did when we were sort of preparing for our opposition. They went down a different sort of route, but it was very interesting hearing their side of things, and also really interesting doing research. Obviously, as we mentioned, that we're not very well versed in this topic, but it's been really nice researching and learning about this. And yeah, it was a great debate.
Thank you very much. Now giving the floor to the two of the three judges that will be reviewing this match for the scores and to see which of the team will continue into the quarterfinals. I would like to give the floor to Professor Isa Adedokun. If there's anything that you would like to share with the teams prior to filling out a grading form, of course, the floor is yours.
Thanks for giving me the opportunity to talk once more. I just want to say that before I go into the presentation proper, I want to say that I don't know, maybe is the audio or the video portion of Arnold Beg. Honestly, I couldn't find opportunity to assess his body language and gesture there, because throughout the whole of presentation, I couldn't see him, and that is a factual truth. But I will find a way to consider other arguments made by the co-debaters in making my assessments. And I want to say that the topic of discussion is topical, and also it has international flavor. And I want to say that it is very difficult really to draw a line between the freedom of the donors and also the freedom of the socials and the proprietary rights of the donor. So, and that is a very tedious task that the presenter will be able to try their best to interrogate. But in the future engagement of a topic of this nature, I would like to see a proper appreciation of international conventions. Some of them mentioned the Article 4 of Universal Declaration of Human Rights, and also some of the European conventions. But I think I noted some of the conventions which I would have loved to see or to hear them discussed during the presentations. And this has to do with permit me to make my video so I can look at that those conventions that I would love to see. These are okay. Yes, I would love to see the conventions. Europe Council of Europe Convention for the Protection of Human Rights and Dignity of the Human Being, with regard to the application of biology and medicine. Also, the Convention on Human Rights and Biomedicine, which actually is the cornerstone of bioethics and biorights. Also, the Article 21 of the Convention, which was added prohibition of financial gain. This is very vital because it has to do with it says that the human body and its parts shall not as source give rise to financial gain. Also, Article 22 of the Convention on Human Rights and Biomedicine also state that disposal of removed part of the human body shall not be commercialized. So these are the points that I would have loved to see during the presentations, which I did not see. But by and large, I want to commend the teams for proper execution of the topic. And this is a very new topic to me. Although it is international law, but I've not looked at this innovative angle of the discourse. So going forward, I'm going to use this presentation to impart knowledge on our students here in University of Lagos. Thank you.
Thank you very much. I believe this is very useful information also for anyone who's interested in the topic to also look further down the road into a bit more aspects in regards to legislation. Also, Professor Graça Innes, if there's anything you would like to share with the teams before filling out the grading form, the floor is yours.
Thank you. Well, I'm not going to add anything special concerning the law or international conventions or whatever, because I think I just want to congratulate the students because this is certainly a new subject for them, and especially the perspective here, the connection between proprietary right of an intellectual property kind and the ownership or the rights of subjects regarding their data, their health data, for instance, or parts of their body. So I think they have done a magnificent effort trying to find some reasoning to relate these two subjects. So that's what I just want to say right now, because they are very young. They are just studying international law, I believe. So I think that's quite a very, very good effort from them.
Thank you very much, Professor. And thank you really to both judges for joining the live session, for the feedback you have given to the students. Of course, we'll share the grading forms once all three judges have filled them. By the rules, there's for 2 business days that every judge has to fill in the forms. Immediately after, the organizing team will validate them and release the forms to the teams and announce the results on our social media. So Facebook and LinkedIn would be the primary results for those that are not directly with the teams or the judges to discover the results. That would be all from my side. My colleague will conclude the session as per the usual tradition for the teams. Well done. Again, it's been a pleasure.
Yes, many thanks, and it was very interesting to see indeed how you argued concerning this, I would say, topic indeed, which is not easy. I mean, it's not something you study in the first years of studies of law, and of course, you have now a bit more knowledge than your fellows, I mean, for the next years. But yes, traditionally, we want to see the connections you might have between the two universities or countries. So, Miss Panait, Andrea Diana Panait, have you been in Lille or have you been in France earlier? I don't know.
Well, I won't lie to you, I've never been to France, but I would definitely love to go. It's one of my dream destinations. So yeah, I would definitely love to visit not only Paris, but the countryside as well. I believe it would be lovely.
Okay, so yes, maybe soon. On the side of Lille, have you been in Mr. Begg, for example? Have you been in Manchester or in UK in general?
Well, no, never. I never had the occasion to go to Manchester or UK at all, but I will gladly come visit one day, I hope, because it's one of my passion to visit new place and go to places that tourists do not usually go to.
Okay, thank you very much. Mr. Beach, have you been in France? Have you been maybe in Lille?
I have been to France, but I haven't been to Lille. I've been to Paris, I think twice before, but actually no, only once, but I only went to Disneyland, so I don't think it really counts.
No, it doesn't. It's not France. Huh? I just know. Yeah.
So I'd love to go though. I'd love to see the culture, definitely the food as well. So yeah.
Mm-hmm. Yes. Okay. On the side of Miss Dwyer, have you been in UK or in Manchester?
Well, I'm actually part British, so yeah, I'm British, so I actually go there regularly to see my family. So yeah, but I like England; it's very nice.
Okay, but in Manchester have you been, or I mean Manchester City?
Yeah, a while ago.
Okay, thank you. Miss Alabida, have you been in France or maybe in Lille?
Yeah, I went to France. I was living in Switzerland before I was living in the UK. And as it's pretty close, like it's just a drive away, we used to go to France a lot. But I've never been to Lille itself, but I would love to go one day.
Okay. Now moving to, of course, the judge, Miss Professor Ines, have you been in France or in UK?
Well, in France, yes, I've been in France, in Paris and other places, but not in Lille. I never went to Lille, no. And in England, I've been in London and some other places, but not in Manchester. So I will have to go to both those places.
Okay.
It was a pleasure. At least I already know you, so who knows?
Yes.
Someday I will go and we can meet there.
Yes, indeed.
Or you can come to Porto too.
Mm-hmm.
Okay, I'll be very happy to have you at our faculty.
I will come for sure. That's, and I hope I will not be the only one, of course. On the side of Professor Adedokun, have you been in UK, in France?
Oh, no, not at all. I've never left the shore of Africa. I never left the shore of Africa, but I hope to visit the UK anytime soon. Okay,
but you can come to France as well, huh? Not just only to UK. But, yeah. Yes. Yes, you are welcome in both sides, and in the Netherlands. I'm in the Netherlands on my side. So, in any case, many thanks to all of you for this match, for this session. Just a few words as well on what will come. The winner of this match will go to the quarterfinals and will be having a match against the winner between the Hague University and the University of the Republic, so either a Dutch university, either a Uruguayan university. So in any case, that was a great match. I want to congratulate the teams, of course, because it's the fourth match for some, it's the second match for the others. So that would be actually, yes, quite, I would say, a performance already for your university in that competition for this year, for this edition. In any case, what you will get afterwards is, of course, a possibility, if you wish, as well, in the final week to come to The Hague. You can, of course, email us if you have an interest to come to that final week to attend or to participate if you qualify for the final. And we'll have some visits of international organizations. We have already some universities who contacted us to join the group at that time. So yes, of course, the judges as well are welcome if they want to come as well at the end of May for the final week for the finals. So many thanks. I give the floor last time to my colleague, maybe.
Yes, thank you very much. And once more, well done to both teams, and thank you very much to the two judges that are present in the session, and of course to our third judge that will be watching the session later, perhaps already now online. Again, it's been a pleasure. The results will be communicated to you on time. We always recommend to check out the recordings of the teams that are in other matches, be that the team that you might be facing in the future, or perhaps a topic that you might be interested in. The group phase overview is already available on the website. It's been updated. Soon the 8 finals will be available as well fully. So definitely keep an eye out. Quite an interesting mix of the debate statement in regards to tangible and intangible property is made available. All right, best of luck and have a wonderful rest of the day.
Many thanks. Good evening.